Hello, my name is Marsha Mavunkel. I chair the immigration group at Swanson, and I'm so pleased to be here today to join my colleagues to give you just a brief update on what's changed with the Form I-9 in the last 12 months. So to start, federal law requires that employers complete and retain a Form I-9 anytime they hire an employee for services or labor in the US. There are several exceptions to that. This can include independent contractors, individuals who are employed outside the United States, hiring employees or placing employees on site that are through a staffing agency, or employees who work in private homes with casual or domestic workers. Other than that, employers should have on file valid completed Form I-9s for all employees. If that comes as a surprise to anybody, I'll just stop right there and say, let's talk. It is a technical violation not to have a completed Form I-9 on file and something that you should remedy right away. So moving forward, we'll start with just the form itself. What has changed in the last 1 year period? Employers should be using the most recent version of the Form I-9. This came into effect November 1st, 2023. The new form is single-sided. It is a single page, which is a nice change from prior editions where we had pages and pages each time that were added to the Form I-9. It is still the smart I-9, meaning that it has certain drop-down boxes to check and drop-down menus that you could select from. And the edition date that you should be using is August 1st of 2023. The expiration date is either the July 31st, 2026 or the May 31st, 2027 date on it. And you can use either for now. As of August 1st, 2026, you will want to rely on the expiration date that reads May 31st of 2027. Some other changes that have been implemented are that we see they have pulled out some portions of the I-9 and changed them into supplements. So we now have a supplement A and a supplement B. Supplement A is that preparer translator portion that used to be ingrained within the I-9, and supplement B, which is the re-verification and rehire section. And that's really nice for employers because especially if you have a workforce where you do have to re-verify often, you now just have a single page that you can print out and use for that re-verification process rather than pulling out a whole new I-9 and using that page that had other items on it. Additionally, now we also see that there is a separate list of acceptable documents page. It was revised to include some additional resources for employers. And this includes listing out the acceptable receipts and providing guidance and links for EADs that can be auto-extended. So for example, you may receive a document, a list A, B, or C document that an individual has had lost, stolen, or damaged, and that they've applied for a new one. And this is when you may be able to use a receipt. Additionally, you may also have employees who work with work permits. These are those EAD cards. Some are subject to an auto extension. And so the additional resources will provide you with guidance on when that applies and how to re-verify the I-9. Sometimes you can use a receipt to show that it was timely extended. Other times, for example, individuals who are in a temporary protected status, they may reference to a Federal Register announcement that confirms that that EAD has been extended for now. There's also a new checkbox on the form. So you may recall in prior versions, there is an additional fields box, and I'll have an image of that later in the slides. And now there is a little box to select if you are using the new remote examination alternative procedures. So on the less pleasant side of what is new, there are some increase in penalties when it comes to Form I-9 violations. So this year in February and June, the Department of Justice and the Department of Homeland Security announced penalties, an increase in penalties for document abuse and discriminatory practices when it comes to the Form I-9. For document abuse, this typically occurs when we see employers ask for specific documents or for more documents or different documents when an employee has already presented a qualifying documents or set of documents to complete Section 2 of the Form I-9. And remember that the standard of review is really a reasonable person standard. If the document appears genuine when you review it and reasonably relates to the individual presenting it to you, then you as the employer should accept it at that point and should not be asking for more or additional documents. The other area is unfair immigration related employment practices. And this can occur if an employer is treating job applicants or new hires differently based on immigration status, if somebody has an accent, anything that you are not using consistent application of your process can give rise to a discriminatory claim. The other thing, just to set some reminders on this, are remember that the best defense, if you are subject to an audit or a claim of discrimination, is being able to show the good faith efforts made in compliance. So what we see during audits, for example, is oftentimes the government will say, do you have a written compliance document? Do you have a standard that everybody follows that's written down showing the efforts that the employer is making to ensure I-9 compliance? Make sure that the individuals in your workforce who are tasked with doing that I-9 review are trained, that they know where this document is, and that they are aware of what they can or cannot ask and what the standards of review are. And also make sure that you're doing periodic internal self-audits. That's another great defense if there is any sort of claims brought. Additionally, if you are using any sort of HR system that has an I-9 system built into it, don't take it at face value. Make sure that it is compliant and make sure that your HR professionals are trained and reviewing the documents carefully when they are being uploaded. So this is just another slide showing the increase in fines. This relates to paperwork violations. And then, of course, it is a violation to knowingly employ an individual who is not authorized to work in the US. So those were also increased this year. So moving on to our alternative procedures to remote examine documents. So this was the big news in the last 1-year period. Just for some context on this, individuals may remember, especially if you've been doing I-9 review for quite a long time, that prior to COVID, it was required that an in-person review of Section 2 documents was completed. And even if an employee couldn't make it to your office to do that, there was a guidance in place to designate an authorized representative, which could be anyone, any adult, to do that in-person review. And this was the standard for as long as these have existed. However, during the time of COVID in March of 2020, the government recognized that with the remote work and a lot of workforces fully working remote, they needed to adjust. And so there was the permission granted to do remote examinations. However, a few years later, towards the end of July 2023, the government said, okay, we are ending COVID flexibilities. They wanted to go back to in-person review with the exception for certain employers who performed the remote exam during the COVID flexibility period, who were enrolled in E-Verify, created a case, and are currently enrolled in E-Verify and participating within it. And so they did say, if you were not in E-Verify at that time, you will need to complete that in-person review. The expiration was the end of August 2023. But this essentially founded what we now see now, which is a new policy of alternative procedures for remote examining of documents. So as of August 2023, employers currently enrolled in E-Verify and in good standing may use video conferencing to examine both identity and work authorization documents presented by an employee. Good standing means currently enrolled in E-Verify with respect to all hiring sites that are using the alternative procedure, utilizing E-Verify to confirm that employment eligibility of newly hired employees in the US, and complying with all requirements of E-Verify. So essentially, you need to be actively using it. The government doesn't want to see employers enrolling in E-Verify just to take advantage of this procedure. They want you to be actively using and complying with it. And there are some additional training videos, things to combat against fraud that are also required of employers who are using E-Verify. As a reminder on what E-Verify is, it is an internet-based system that allows the government to, it's a cooperation between Department of Homeland Security and the Social Security Administration. They review the documents that are submitted to E-Verify, your I-9 documents, and then provide an analysis and confirm that person's identity and work authorization is valid. It is generally optional for employers to engage in it. There are caveats that, of course, if you are in a federal contract that requires it and certain states that require it as well. But, of course, they are incentivizing using it because you do get to utilize this new alternative procedure. So I've spoken to a number of employers who are now saying, well, can I enroll now? And the answer is yes, you can enroll now and you can take advantage of the alternative procedures once you are enrolled, using that system, of course, moving forward routinely at that hiring site. So what are the required steps? Employers may use this alternative procedure for remote hires only. Just as a reminder, you can use it Also, just for remote hires, if you have a hybrid workplace where some people come in person, some people are fully remote, you may use it only for remote hires. You might also use it for all hires. There is that option as well. The first step is that the employee will send a scan of the front and the back of the documents to the employer. This will allow the employer to confirm that it is legible. You can do an initial review of the document. Then they will engage in the live video conferencing with the employee. And the employee will show the front and back of the document to the employee who is reviewing the I-9 document during the live video conference. And that same person who's reviewing it should complete Section 2 and sign that I-9 form. The employer will indicate on the Form I-9 that the alternative procedure was used, and I'll show you in my next slide an image of that additional information box and the new checkbox that's been put in there in the newest version of the I-9 that needs to be selected. And then you are required to retain clear and legible copies of the documents used in Section 2, and that is a requirement distinct from when you just complete a Form I-9 where it is optional that you retain copies or don't retain copies. Using E-Verify, using this alternative procedure, an employer must retain copies. And also a reminder that typical timelines apply when it comes to Section 2. As you may recall, it is a 3-day rule to complete Section 2. So if your employee starts on Monday, make sure that this is done by Thursday. And here is an image of that new field, that little checkbox you can see in the bottom left-hand corner. It just says, check here if you have used the alternative procedure authorized by DHS to examine documents. Within the Federal Register, which is where the government published this rule, they also included some FAQs. So I've just listed out a few that come up fairly often as far as this new alternative procedure. So one is, do employers have to use E-Verify to create a case for all newly hired employees to use this procedure? And the answer is yes. You must be an employer in good standing with E-Verify, and you must be actively using E-Verify. So creating a case, going through all the steps, doing that training. Secondly, can a qualified employer choose not to use alternative procedure? And the answer is yes, you can absolutely continue to conduct in-person physical examinations of documents. As I mentioned earlier, you can also choose to say, just do it for your remote employees and still do in-person for the employees that come into the office. If an employee tells you, I don't want to do the alternative procedure, I want to come in person, of course, as an employer, you should accommodate that if they're unwilling or unable to do the live video conferencing. Can employers choose to use the alternative procedure for some? I just kind of jumped right into that with my last question as well. And then finally, if an employee does not want the employer to apply the alternative procedure with respect to that employee, can they refuse? And yes, again, you do want to provide them that opportunity. If they're not local, you can still use that authorized representative option. And again, any adult can do that, including a family member, just keeping in mind that some states have rules against notaries doing it. So that is the program in a nutshell, and some of the frequently asked questions that we hear on our side. Don't forget that if you are using it, there are some additional trainings and things that E-Verify requires to implement it. And if you have any other questions, those are our primary updates this year for the Form I-9 and the big news of the alternative procedures that are being implemented.